Okay, so the key takeaways is that we were looking at various topics that relate to big data and big tech and all the various cases. And so one of the most important things is what's the importance of self-preferencing and this difference between tying and bundling, do these distinctions matter? And I don't think there's a lot of clarity there, so I hope this panel really gave a little bit more certainty as to these areas in the law. Then we moved to remedies and we talked about counterfactuals, the importance of counterfactuals, particularly as it relates to the new Google case and its new remedies, and whether we can really measure this and what courts need to have assurance that their counterfactuals are really useful and valuable in terms of setting the right remedy in terms of that. Then we moved on to scale, and the importance of scale arguments is increasing importance in complaints. I find that this is something we really need to get a finger on because right now it just feels like there's a lot of uncertainty what scale means, what concept, what's enough, is it sufficient just to mention it, is it correlated with size, and I thought a good response was that scale could also be very good for consumers. And so we also talked about Ohio versus American Express, which is the key precedent with platforms, and so I think that discussion is pretty valuable because these are people who are on the front lines implementing that case, and so their sort of insights and discussion on that case I thought were really valuable. So with that, I think those were the key points of the panel, and I really think it was very fruitful.